Welcome back. I'm Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today we're going to unravel a crucial yet often overlooked component of estate planning, the power of appointment. What is it, how does it work, and what's the point? Let's dive in. First things first, what exactly is a power of appointment? Imagine you've been put in charge of a supply chain for a widget company, and you've been given $1 million to allocate how you see fit. In estate planning, a power of appointment works in a similar fashion. It's an authority that a person, known as the donor, gives to another person called the holder or the donee, allowing that holder to decide how to distribute certain property. Now there are two main types of powers of appointment, general and limited. Firstly, we have a general power of appointment. This gives the holder the ability to distribute the property to pretty much anyone. They could even appoint the property to themselves. Essentially, I leave my estate to my executor to allocate wherever they see fit to do so. However, then we have limited or special powers of appointment. Here, the donor defines a specific group that the holder can distribute the property to. This group oftentimes does not include the holder themselves. For example, I leave my estate to my son, who must then allocate the assets to a charity of his choosing or his 3 children in a manner in which he feels best. Before going into how to create a power of appointment, let's briefly discuss why you might create one in the first place. Powers of appointment can be versatile tools in estate planning, providing flexibility, control, and potential tax benefits, with flexibility likely being one of the most compelling reasons to create such a power. A power of appointment allows the holder to adapt to circumstances and make decisions about asset distribution based on family dynamics at the time of death, rather than when the will or trust was created. Going further, the flexibility provided can assist with generational planning. For example, mom leaves property in a trust for her children, with each child holding a power of appointment over their share. If a child dies without exercising their power, their share can be appointed among their descendants, keeping the property within the family. Powers of appointment may also allow for planning around potential taxes that might be otherwise unavoidable absent such a power. Additionally, if a beneficiary has creditors and they don't want to appoint their share to those creditors, something they do have the power to do, a carefully designed power of appointment may allow the beneficiary to direct where their assets go without it being accessible by their creditors under the rationale that those assets are not owned by the beneficiary. However, this is something you should have an attorney assist with to get it right. By this point, you might be wondering, how do we set up a power of appointment now? Well, it's essentially established within a document such as a trust or will. The settlor, the person creating the trust, includes specific language granting either a general or limited power of appointment to a specific individual. It's often best to put this power in one's trust rather than their will, as wills are subject to probate and all the fees, time delays, and just headache that probate requires. Put the language in a trust, and we don't have to worry about court involvement. So once a power of appointment is established, how can it be exercised? Well, the power of appointment is typically exercised through a separate legal document like the holder's own will. It must evidence the holder's intent to exercise the power, be signed by the holder, and refer to that power. There is the concept of an implied power of appointment in the creation or exercise of such, but never hang your hat on the implications of powers that should otherwise be explicitly stated. Implications require proving such. Explicit declarations are self-evident. Now watch out. There are some common misconceptions about powers of appointment. One is that the holder of the power of appointment owns the property. This isn't true. The holder has control over the distribution of the property, but does not own it outright. They cannot use the property for their own benefit unless they have a general power and they appoint the property to themselves. Also, a general power does not mean unlimited or unrestricted authority. A general power may still have some terms to follow, and exercising a general power of appointment must be done in good faith and not violate the purpose of the establishing instrument, the will or trust, to begin with. Understanding the power of appointment can greatly influence how you plan your estate. As always, the specifics can be quite complex, and you should always consult with a professional to fully understand your options. Let me know if you have a topic you want me to cover, or if you have any questions by dropping a comment below. Don't forget to like this video if you found it helpful, and subscribe to our channel for more easy to understand insights into estate planning, taxes, real estate, and finances. Feel free to watch our last video or check out another great one.